Alliance's Crypto Roundup for the week ending June 9th, 2023. My name is Ron Quaranta, chair of the Wall Street Blockchain Alliance. Our usual disclaimer, friends, everything discussed here, nothing should be considered accounting, investment, legal, or tax advice. Our special guest this week, dear friend, is Louis Cohen of DLX Law. Louis, how are you, sir?
Hey, I'm great, Ron. Thank you for having me on the show. I love it. Great to be here.
Excellent. Appreciate it, my friend. I know our co-host David couldn't join us. I know Josh is trying to join us, so hopefully she can join us a bit later on. Louis, every single week that goes by in crypto land and blockchain land, I think, how more busy can it get? And then we end a week like we ended this week. We talked about, and you and I talked about earlier in prep, SEC coming out swinging again, Binance lawsuit, Coinbase lawsuit. Very different suits perspective, but as an attorney, I'd love to hear your perspectives on the suits, and you and I can kind of peel back the layers of what's important there.
Absolutely. Well, let me just say, I don't want to jinx anything, Ron, but today is not over.
Today, that is true.
We got about 5 or 6 hours, and in crypto, that's a long time. You know, that's like when you're down by 10 points at the 2-minute warning. We got plenty of time. You know, so I don't want to see, what's coming. So, yeah, so a lot has happened, as you said, particularly as you noted, 2 major complaints that I think everybody had been largely expecting. But finally, we have them in our hands. We can review them. We can try and understand them. What do they mean for the industry? What do they mean for different kinds of market participants? How do we use that to kind of project forward a bit? And of course, in addition, just on Friday of last week, the chairs of 2 critical House committees, Financial Services and Ag, released a joint proposal on market structure for crypto. So a lot to digest for folks in this space. And of course, there have been some other things as well. And there's our friend, Josh Klayman. Hi, Josh.
Hi. How are you guys?
Josh, we just started. We are live. Louis and I were talking about the Binance suit and the Coinbase suit. Josh, you and I had the opportunity to meet with an agency yesterday. I'll dive into that without naming the name of the agency. But Louis, Josh, I wanted to peel back the layers. I was just mentioning, Josh, how there's never a dull moment in crypto. I would argue the Binance case and the Coinbase case are markedly different in many ways. Do you agree with that, Louis and Josh? And why is that delineation important for the space?
So I have a question, and my apologies. I was having a little bit of trouble accessing. So apologies, everyone. Now, Ron, I guess my question for you is, do you mean different from each other or different from what we've seen before?
I think I mean different from each other, at least at the outset. Now, different from what we've seen before, yes, agreed. But let's parse that down. Give me your perspectives on what's different. And one of the questions I had from colleagues in the space is, colleague at a TradFi, which is which one was worse? And my response was, they're both terrible, but there are different ways of looking at it. Josh, how do you see that?
So I would say, if I'm looking at the differences broadly speaking between the two, I mean, there are some serious, I would say, even though they're civil complaints, there are some serious criminal-ish allegations in finance. Alleged, yeah, allegations, yes, against some key people, and some pretty shocking, I will say, quotes. Also, the fact that the SEC is seeking a TRO, I mean, that's a big deal. I would say that in the Coinbase complaint, by contrast, while we see many of the same types of charges, it seems to be in a much more measured language that doesn't sort of call into question the very credibility, or I don't know, the right word is escaping me, but it doesn't have the same sinister feel in the allegations.
Do we read anything, Louis, into the fact that in the Binance case, the CEO of Binance is actually specifically cited as part of the case itself, whereas in Coinbase, Brian Armstrong is not? What do we read into that for the non-lawyers in the world?
Well, again, we're all surmising here based on public information, but there are strong allegations, as Josh was just saying, in the Binance complaint, that the relationship that their CEO had, not only with the 2 primary Binance entities, but with a number of other named entities who are also all controlled by him, created a whole sort of wider scheme that, at least in the allegations, if they're to believe, are largely, bordering on potentially criminal in terms of the malfeasance involved, and that the CEO in his individual capacity seems, at least to be alleged, to be controlling this kind of whole, illicit organization, if you all believe the complaint. And so that's very different. In the Coinbase complaint, Brian Armstrong, the chief executive, is not named. And, it's not suggested that there's more to it than just basic violations of the law, which we know there have been differences of opinion. And, there's no clear certainty, I would say, on either side. So that is an important distinction to bear in mind. Yes.
I thought there were very similar perspectives, and I don't want to weigh in on this too much from a legal perspective, but it felt very similar to reading the FTX complaints in many regards.
The Binance one.
Yes, correct.
Yes, absolutely, yes.
Yeah.
And this, the commingling aspects, the alleged fraud aspects, really do highlight, in my mind, the critical differences. I want to peel back the layers a little bit, and I know I'm kind of moderating this. We didn't mean to do it that way, Josh. But the thing, when I look at Coinbase, when you look at the public record of Coinbase's visits with the SEC, there's a lot of hyperbole going around. Binance's CZ has come out publicly and said Chair Gensler was going to be an informal advisor to us. It feels very gossipy almost in many, many ways. But Coinbase's argument is that they've tried to do it the right way, and the SEC's response generally, or at least in broadcasts like CNBC and others, the chair's response is, no, you just don't like the rules. And I think there's a truth somewhere in the middle that everyone's missing. But what is? Do you both agree with that? And I don't want to say who's right, but both sides can't be perfectly accurate in the discussions that we're talking about. What do you both think?
So it's hard to know because we weren't there, but hopefully we'll find out more as these cases progress. I will say, Ron, kind of echoing what you and Lewis both said in a way. If I were to imagine these complaints as part of a movie, I feel like the Coinbase movie would be rather dry, right? Whereas with the Binance movie, it seems like there would be twists and turns potentially based on these allegations. I mean, I will say, although names were redacted, I think it's easy to tell who was being quoted in many cases, and actually, some of the kind of mysteries of the space, we got a little bit of insight into what might have actually happened.
I'm still wondering who's going to weigh in on the movie rights for either of these cases, and I suspect there's an FTX movie in the works as well. Lewis, what are your thoughts on that?
Yeah, well, Michael Lewis is just, I guess we're still waiting for his FTX book. We have to wait a little longer. I mean, for me, Ron, we talked about differences, but there are a lot of similarities. And as a lawyer, I think where I feel most comfortable commenting, right, the legal arguments being made in the two complaints really at their core are similar, right? And so they really turn on something that, as both of you guys know, we spend a lot of time thinking about. Are these tokens, when traded between two kind of random people that have nothing to do with the project, are those tokens just themselves securities? Because that is the foundational question that the SEC is going to have to address in both complaints, right? There may or may not be a criminal complaint against Binance and their CEO in his individual capacity. We'll wait and see. But as to the SEC claims, they're going to have to establish that securities were involved. And hold aside for a moment, there are different arguments with the earned products or equivalent to the earned products. That's a little bit of a different thing. But for the core allegations that both platforms were acting as broker-dealers, they were acting as exchanges, national securities exchanges, and as clearing agencies, those allegations all turn on, as they say at one point, I think it's in the Coinbase complaint, at least one of those assets is a security.
Identical language in both complaints, actually. Mm-hmm. They it looked like copy paste. Yeah. No, that they just have to show that. I think they said the existence of one crypto asset security. There was some interesting language, Lewis. It made me think of you.
In a legal complaint.
Because, no, not for any factual reason or any legal reason, really, but really because of some of the language. There was a mention the way that these digital assets were alleged, although they did say crypto asset securities in that part about talking about the Exchange Act violations and what it requires, elsewhere they used language that was more along the lines of a crypto asset that was offered and sold as an investment contract and therefore a security, right? As opposed to saying these tokens are securities, which I thought was, whether intentional or not, lends itself to some very interesting potential arguments about the separation of the investment contract and the token. So that's the part that reminded me.
Interesting. And shout out to Tuan, who just posted a question, and it really neatly leads me into where we're going next. So Tuan mentioned that delisting of certain pairs from Binance US seems to be construed as guilt. I would love your legal opinion on that. What I took out of that when I had seen the news of that was very much as a follow-on onto the TRO that you mentioned, Josh, which is around stopping U.S. bank dollar access to Binance. I think Binance US recently posted as early as this morning that essentially they're not taking dollar deposits, and there's get them out essentially. Oh, do we construe guilt in those actions, or do we construe like the house is burning down, get out?
Well, I think the SEC has really tried to have it both ways, because whether it's in the Binance complaint, the Coinbase complaint, or other complaints, you feel a little bit damned if you do, damned if you don't. You don't take any actions. Well, you're derelict. You're not paying attention. You obviously you don't care about securities laws. You do pay attention. You do some actions. And I think we saw this, Josh, in the Bittrex complaint as well. You're taking actions and trying to get people not to make statements that would make it sound like you're pitching an investment scheme, and that you can't do that either. So I think there's a little bit of an issue there. I think it would be preferred from a policy point of view, right? If the SEC could be a little bit more clear, what do you want people to do? Do you want people to delist pairs when they are concerned about to be a security? Or is that indicia, as Tuan says, is that indicia of, well, you knew there was a problem and now you're, so I think it leaves market participants, and this is Coinbase's real point that they make over and again, appropriately, right? How are we supposed to know? Tell us where the rules of the road are. We don't want to go driving around the parking lot, bumping into things. Paint some lines and let us drive through the lines, right? And they're refusing to paint lines. And so then yelling at you when you bump into a car. You're like, well, hang on a second. Let's figure it out.
Yeah, Louis, to that point, though, and Josh, feel free to weigh in just real quickly. That really runs smack into the wall of the chair's comments and the SEC's comments, which are, we don't need to paint bright lines. There are bright lines. You just don't like them and you ignore them. Is there, it seems a bit disingenuous to those in the crypto space, but is it? Josh, what are your thoughts?
Is it bright lines?
Well, argument from the SEC that there are bright lines, the law exists. And Louis, to the point you just made a bit earlier, they're not.
Yeah, I think this is the thing. The reason that many of these tests are facts and circumstances is because that's the opposite of a bright line, right? There are no bright lines here. So I think, again, as I've probably said so many times, you guys are sick of it. I think some aspects, it's clear what the SEC thinks.
Sure.
That may not be what a court thinks, right? And then there are some aspects where, we don't know what the SEC thinks. We don't know what the plan is for all these existing tokens that the SEC may allege are securities and not properly issued. So I would divide it that way. I would also just emphasize, the statements that were made by Chair Gensler following the filings of the complaints about, we don't need digital currency, we have the US dollar.
Yep.
Oops.
I think you're cutting out, Josh.
There's a really good spot in the movie, too. I wanted to see what happened next. Well, maybe while we just let Josh, hopefully your computer will reconnect. I was going to make a somewhat similar point, but I think a little different one. So I'll let Josh finish your thought in a moment. What I was going to say, when Chair Gensler testified before the House Financial Services Committee 6 weeks ago or so,
yep.
Chair McHenry asked him repeatedly, well, is Ether a security? And he could not respond. He kept repeating over and over again, it depends on the facts and circumstances. Well, if that's the case, if you yourself, who tells us is clear, say when testifying before Congress that you don't know, then how do you reasonably expect other market participants to know? Which facts and circumstances? How is anybody supposed to know? He didn't say, well, for example, sure, it's facts and circumstances. If you do this, this, and this, then likely it is a security. But if you do that, that, and that, then it's probably not. Oh, okay, that's super helpful, right? Instead, he just says, I don't know, depends on facts and circumstances, but you should figure it out. So I think that's a good example of the challenge that the SEC has faced. They've also sort of teed things up, and Josh was making his point just a few moments ago.
Yep.
Sometimes they say the asset is a crypto asset security, but then other times, and more recently, they seem to have moderated that position. So they themselves don't seem to have a consistent position on what the law is, right? Well, are they actual securities, or they're offered and sold as contracts and investment contract transactions? Very different. A lot of different implications for that, right? So we kind of need, as market participants, we would like clarity around those kind of things that we clearly and rather self-evidently are not getting.
Louis, you've been in this space for a long time, and you've had deeper legal thoughts than I'm certainly ever going to have about what's happening in crypto. But does this ultimately sort itself out in the courts? Is that ultimately the output that we need, some weigh-in by the courts? And Josh, we'll get back to your digital dollar comment in a second. We've kind of gone in a slightly different direction. But Louis, what are your thoughts?
I totally want to hear Josh's response.
We're going back to that. Yes.
Yeah, but just to quickly finish answering, I'll give a short answer to your question, Ron, which is yes. No, seriously, I would give a little more than that. But yes, I think the courts are going to play an important role. And I think Josh was making this point a bit earlier. These are principles-based tests. They are facts and circumstances-based tests. And over time, as lawyers in a common law-based system, which is one that looks to judicial precedent to help lawyers. Whoops. Well, man, easy come, easy. Oh, there we go.
Oh, Josh.
Oh, we lost you for a second there again. So in a common law system, yes, the courts are going to play, I think, quite a critical role. And I think courts have been skeptical. I think we saw a couple of things recently that evidence the skepticism that courts have, in particular around the level of deference that regulatory agencies should have in interpreting the law. And then, again, in the case involving Slack technologies, the Supreme Court expressing skepticism about the Ninth Circuit sort of interpreting very broadly the securities laws to achieve a policy end that the Ninth Circuit Court of Appeals felt was inherent in the statute. And the Supreme Court said, well, it's not for you. There's a plain meaning here. We found the plain meaning. And if that's the case, if Congress wants to elaborate, that's their job. Josh, I know we're coming back to your point.
Thanks. And by the way, my apologies. I haven't moved. I don't know what's going on with the connection. But what I would say is, with that comment where Chair Gensler said we don't need digital currency, we have a digital dollar. Again, as I was saying, what does that have to do with the securities laws? And moreover, isn't that evidence for those who would allege that actually this isn't technology neutral regulation at all? Yep. This is aimed at specifically at an industry and a technology that is the regulators, or at least Gensler, thinks should fail. And who knows? Not to take it too far. Sorry, Ron.
No, I'm sorry.
But when you think about what's been rumored about whether he has his designs on Treasury, well, what's in Treasury?
And it makes you worry about the impact that these almost political conversations seem to have. And we've all seen crypto advocates and colleagues in this space for a long time immediately seized upon the words of, we don't need more digital currencies, we have the digital dollar, as the flag for the incumbents, that he's picking winners, or at least regulators are picking winners in this ecosystem. And shockingly, the winners are banks and qualified custodians and the US dollar and Treasury. And I think it's really not a far reach to argue that there might be credence to that. I want to go back to one thing, if I could. And speaking of the courts, and speaking of, some of this seems to be about waiting it out, right? For colleagues in this space, it's waiting out court cases. Bluntly, it's waiting out the SEC chair. Many colleagues have raised to me. But I'd love your perspectives, because that's a multi-year process. Court cases like this aren't going to be resolved by next weekend, for example. What are your thoughts about the impact that has on the industry? I have a lot of colleagues. WSB has members overseas, and their feedback is you're losing out, you're losing ground. What do you both see of that? Louis, we talked about that in prep earlier. What are your thoughts?
Yeah, it is. It is very concerning, and you're starting to see not only one side of the partisan divide pick up on that, but both sides, in Congress asking questions about, look, where are we positioning our country for kind of the next generation? And it certainly is specific as to blockchain and crypto, but that message kind of permeates through. So if this technology is out of favor today, what other technologies are going to be out of favor in the future? So yeah, I mean, I can sort of attest, and I suspect Josh, you can as well, of clients that we work with, that, hey, I'm leaving, I'm taking my business, and I'm getting out. I don't feel welcome here as an innovator. We're not doing anything wrong. We're not violating any laws. We just feel unwelcome. So that's a very concerning thing for the future, for our kids' future, et cetera.
Yeah, I mean, I agree with Louis. No surprise. I think a few things. Just going back to Gensler for a second, my favorite topic of the past few minutes. I think what he said shows not just a bias against the industry, but it shows a fundamental misunderstanding for the potential, right? And the uses of digital assets and tokenization and any other number of things that go beyond what a dollar does. So there's that, and I think that that's troubling. I do think, though, if we think about the sort of double-edged sword that not just the regulators bring up, for example, if you remove a problematic statement, will that be cited like it was in Bitrex, right? Other sorts of things. If you remove a token, will it be deemed an admission of guilt or liability, right? But beyond that, we also have to remember we might say, okay, we're going to wait it out for 3 years or however many years litigation takes. But you know who's not going to wait it out? Plaintiffs' lawyers. And so I think that's another layer of what technologists need to deal with, and where if the regulators are very concerned about protecting retail investors, retail purchasers, users, and the like, it stirring up these battles that aren't going to be resolved quickly. It goes beyond just the regulatory effect.
Josh, thanks. And for everyone that's watching, thanks for joining us. Please do keep questions coming. One of the LinkedIn users, and interestingly, I didn't see Chair Gensler's interview, and I say this half snarky in his usual media junket after every big case that they launch. I didn't see the Piper Sandler FinTech conference, but the viewer argues that he very clearly noted all coins are securities. Did either of you see the commentary, and do you agree with that?
Well, I saw the printed remarks, but looked at them briefly. But I think the commentator is absolutely correct. I mean, the SEC is increasingly making it clear that you should assume every single crypto asset is a security. They have omitted, a small number of major tokens, but there's no suggestion that the ones omitted they're comfortable with are not securities. And they've picked, tokens from various different walks of life, different ways they were originated. One of the tokens mentioned, ADA, was very clear. The Cardano token was done, any sale they say was sold in an investment contract transaction. Well, fair enough. It was sold in an investment contract transaction outside of the U.S. where it wasn't an investment contract transaction. So how's that work? So I think at this point there seems to be nothing that in the SEC enforcement team's mind would result in something not being a security, and that's just where we are. And as lawyers, we counsel our clients accordingly.
Yeah, and I think also. Sorry, I was afraid I was losing connection again for a second. I think if we think about the bigger picture right now, it seems that just as Congress and just as Chair McHenry and that team have introduced this market structure draft discussion draft legislation.
Yep. Josh's instincts were correct. Oh, no, you're back. You're back.
Her sense of suspense is astounding.
My apologies to the viewers and to both of you. My gosh, I literally haven't moved. So yeah, maybe Gensler's watching this. I don't know. But yeah, no, as I was saying, which now my train of thought is disrupted a bit. But yeah, at the same time that we're seeing this focus on market structure by Congress, it seems that there is this massive push by the SEC to put everything out as a playbook, right? Not just the rules and at least in the case of the proposed definition of exchange that they proposed to expand, right? The Reg ATS. Not just to address every comment, but just to really make this comprehensive. If you look at both the Binance and the Coinbase complaints, to me, this is like a roadmap of everything that they've covered previously and more. And so I think it's almost like, okay, Congress may be finally ready to act, maybe, right? Or some in Congress. And
Congress
the
gets
SEC
something done? Now, come on, Josh. Sorry.
I'm just saying whether or not it actually happens, it does seem that the SEC and Gensler are in a hurry to show we have a comprehensive market structure and here's how it's supposed to work. And whether that pushes Congress to make a change because they do see innovation flying out, literally flying out of the country, or whether the SEC says, look, we have everything in place, this is how it works, there are no questions, this is how the pieces fit. I think in that sense, it's not a surprise if Chairman Gensler is saying everything is a security, because guess what? If something isn't a security, then it doesn't fit in the box.
Yep. One of the things that were interesting to me in the wake of these, I'd love both of your thoughts on this, were those second order effects. And what I mean by that is I was stunned. David Brill, our co-host, couldn't join us today, but he and I often look at price action. You would argue that two massive cases like this would negatively impact crypto prices, including BTC and Ethereum. BTC is only down 2% on the week and actually sustaining in the 27,000 level. So that's one of the first order effects, second order effects. The other one was interesting, and I think it was news this morning, that Robinhood has decided to delist or no longer support at least some population of the tokens that were raised in these suits by the SEC. What do you make of this kind of reaction from the marketplace? Do you see this getting worse for the marketplace, or how do clients talk about this with both of you?
Well, I guess I would say, just as to that, continued uncertainty is rarely good for business. People, like to know, if I'm deploying capital, what's the environment I'm deploying it into, and how will that affect my risk reward determinations. If you just don't know, things can get better, but they can get worse. It's really hard to judge how much capital do I want to deploy. Am I starting a new business? Am I investing in tokens? Am I investing in a company that provides services to people in the space? Am I, doing all kinds of things? We're constantly making economic decisions about where to deploy our time and our value in terms of capital. And so that uncertainty, Ron, clearly, slows things down. I did see a LinkedIn user, which may or may not be the same LinkedIn user, followed up on
They're going anonymous on these conversations, Louis.
All good, yeah. I didn't see a place, Ron, in the format here to put a link of our own in, but I wanted to put a link to our article because it's very direct to address the point. So the commentator notes that Gensler's point was a very fundamental and powerful one, that the value of any coin is derived from people's activities, especially when the stakeholders go to conferences, drumming up their chains to gain more adopters. And we're very familiar with this concern. The issue isn't whether at any given moment there is some third party who is taking steps to induce people to kind of buy assets. That by itself does not make an asset a security. It may raise concerns about what those person's behaviors are and why they're doing it, and they may be subject to regulation. That's not what's at issue here. What's at issue is where two people, if Josh and I trade an asset, and there's Ron, who promoted the asset, is going to conferences saying, man, this thing's crazy, it's going to be great. Are Josh and I entering into a securities transaction? How do we know? How do we know that what Ron says is actually speaking for or in any way related to this? People say all kinds of things all the time. The challenge here is, our securities laws apply to legal instruments that create relationships between two or more persons. If you look at any other security, what you'll find, whether it's an equity security, a debt security, or something else, is there's a legal relationship. I lent Josh money, now she owes it to me. There's a legal relationship there. I invested in a company that Josh started. I'm entitled to a share of profits if there are dividends declared, or a liquidation if the company is dissolved. with tokens, if you own an Ether token, you can't go rocking up to Vitalik's door and, hey, Vitalik, do this, that, or the other thing. The Ethereum Foundation, Consensus, the company, anybody, tokens don't create those kind of legal relationships. And so that doesn't mean they shouldn't be regulated. It does mean that they are not securities.
Go ahead, Josh. We've only got a couple of moments. We can go on like this for hours. I know both of you well.
Yeah, I would say that, and I will both touch upon Robinhood and also just say I'm not touching upon Robinhood at the same time, because there are a few different thoughts that come to mind. One is, while Coinbase and Binance may have the wherewithal, the desire, and the pockets to continue in litigation with the SEC for a long time, others might not want to be engaged in that at all. And so it may be a decision, just a risk-based decision that people make about whether they want to hang tough, so to speak, and retain certain tokens or not. Now, with respect to Robinhood, and this isn't, I have no inside information about this, but when I think about some things that happened to Robinhood in the past, what comes to mind, among other things, GameStop, right? And so, you never know what could motivate, what kind of past experiences and concerns could motivate them to take a more conservative view and perhaps delist certain tokens, because we certainly have seen scenarios in which lawsuits and other sorts of challenges in terms of well, I won't go into it. People are familiar with what happened generally with GameStop, but yeah, so you never know, but not. And this is something I think is really important for clients as well. Again, just like there's a difference between the question of what do we think Chairman Gensler and the SEC thinks, and what will a court think, and what will the ultimate answer be, there's also a question about what might you do if you don't ever want to be in the SEC's crosshairs versus what might you do if you're willing to fight it out.
Right. I want to wrap up with one thing, and I don't mean this to be a continually bashing of Chair Gensler. It certainly is not much.
Oh yeah,
but no, but I think one of the interesting aspects of these conversations is this pushback very publicly that everyone involved in the ecosystem is fraudsters and Ponzi schemes and hucksters, that everyone involved is actively looking to not be compliant. And that feels like a little bit of hyperbole, given the work that we've seen in this space. Do you agree or disagree with his comments? And how does an industry respond to that in a way that makes sense? Louis, do you have any thoughts?
I'll go first really quickly. Oddly enough, I don't agree. No, I don't think that the industry is exclusively. I mean, there are a lot of problematic, players, issues, et cetera. The phrase I suspect both of you have heard me use before is that when you open a door, you let in a lot of fresh air, and you also let in a lot of flies. And it's the nature of open systems that, yes, it brings in a lot of fresh air, a lot of benefits. It also allows a lot of things to kind of come in that you may not want to come in. And I think the role of regulators, and they're not, generally speaking, these are not high-paid jobs. These are people, public servants. They are trying to protect us, and we should encourage them, and we do. But we have to recognize that the bad actors should be weeded out, but they're not. Everyone is a bad actor. So that's my quick take on that. Josh?
Yeah, and I would also say, like, as Louis says, many of the staff, including at FinHub, they are deeply concerned. In my experience, they've been deeply empathetic, sympathetic, all sorts of things. And I know that they are, I believe that they are dedicated. Similarly, yes, there are some bad actors in every industry, just like in the startup world, lots of companies fail, right? It's not
Elizabeth
something.
Holmes, 71, right?
Exactly.
Yeah. Exactly. Fraud occurs because people are people. I do think, in Chairman Gensler's defense, if I would, he's pretty clear on his view. We kind of know what he thinks, maybe not with respect to say Ethereum, right? And that, but generally speaking, we kind of know what he thinks. But I don't believe that the comments that he makes are helpful. I don't think that they are. I think that it seems that there is a real, the SEC has more than one mission. It has a mission of investor protection, and it also has a mission as to capital formation, right? And I just think that is something that is being left by the wayside, it seems. And again, I think Chairman Gensler's recent comments, they're not technology neutral.
Right. We are over time as usual. Our guest, Louis Cohen, DLX Law. Louis, always a privilege. Josh, thank you for co-hosting with me. We'll be back next week. I suspect we'll be talking about these things for a long time to come. Hopefully, David will be back with us next week as well. Louis, we hope you'll come back to us again in the future.
It's very kind of you guys. Great to talk to you both.
Have a great weekend, everyone. Cheers.
Take care.